Welcome to the Tennessee Department of Education's overview of Title IX. My name is Chandrea Hersey, and I'm the Assistant General Counsel for Civil Rights in the Office of General Counsel at the Tennessee Department of Education.
Hello, my name is Natalie Perriman, and I'm a staff attorney with the Tennessee Department of Education's Office of General Counsel.
Hello, my name is Nikki Keene, and I'm a paralegal at the Tennessee Department of Education Office of General Counsel.
This training will provide an overview of Title IX. It will discuss the obligations that school districts have in responding to complaints or concerns of discrimination or harassment based on protected classes of sex and gender, and it will provide additional details of different issue areas that are covered under Title IX.
So going into the training, these are the department's strategic goals under our Best for All initiative. So we focus on academics, student readiness, and educators. The goal behind these initiatives are to make sure students can thrive in the educational setting. Today's training will focus on a general overview of Title IX, as well as discuss the requirements for Title IX sexual harassment grievance process. So we'll begin today's training with an overview of Title IX. Title IX of the Education Amendments of 1972 prohibits discrimination and harassment on the basis of sex and gender in all public schools. On August 14, 2020, the Title IX regulations were updated to address complaints of sexual harassment. There have been additional proposed changes to these Title IX regulations that were issued in June of 2022. Some highlights of these changes are that it revises the definition of sex discrimination, the scope of federal law, and grievance procedures. The U.S. Department of Education started the review of the regulations in the spring of 2021, and they accepted feedback in public hearings through summer 2021. It issued proposed rules in June 2022, accepted public comments through September 2022, and comments are being reviewed and incorporated with the anticipated effective date of October 2023. Proposed changes to the regulations were issued in April 2023, and these changes were related to participation in athletic activities. The U.S. Department of Education began the review of the regulations in summer of 2022. They accepted feedback and public hearings during the summer and fall of 2022. They issued proposed rules in April of 2023, accepted public comments through May of 2023, and comments are currently being reviewed and incorporated with the anticipated date of review being October of 2023. There are additional issues to consider when dealing with Title IX. Those involve athletic opportunities and benefits and pregnant or parenting students. With regard to athletic opportunities, remember that this is a developing area of law. Consult your board attorney and Title IX coordinator if you encounter questions about athletics and Title IX. With regard to pregnant and parenting students, remember that pregnant and parenting students are also protected by Title IX protections. Again, this is an area where you should consult with your board attorney and Title IX coordinator if you encounter questions about this issue. Regarding sex and gender, Title IX prohibits discrimination and harassment based on sex. This includes sexual harassment. Title IX also prohibits discrimination and harassment based on gender, and this includes gender norms, gender expectations, and sex stereotypes. With regard to LGBT students, remember that all students, including LGBT students, are protected from harassment based on their sex or gender. This includes sexual harassment and gender-based harassment. Harassment that is not prohibited by Title IX may still be prohibited by the Tennessee harassment, intimidation, bullying, and cyberbullying laws. So remember, a district always has a responsibility to act should these issues arise. An example includes harassment based on sexual orientation, height, weight, appearance, gender identity, socioeconomic status, or other areas. Remember that this is a developing area of law. Be sure to consult with your board attorney and your Title IX coordinator if you have questions about this issue. Under Title IX, all persons, regardless of gender, are prohibited from engaging in discrimination and harassment. All persons, regardless of gender, are protected from discrimination and harassment. This conduct does not need to involve members of the opposite sex. Students are protected from harassment from other students, school and district employees, and third parties such as contractors, school visitors, and the like. So under the scope of Title IX, it applies to programs or activities that receive general funds from the Department of Education. It applies to all program areas, including academic, So under the scope of Title IX, it applies to programs or activities that receive general funds from the Department of Education. It also applies to all program areas. This includes academics, extracurricular, and athletics. It also applies to all activities of a school, even school activities that occur off campus. However, under Title IX, as it relates to sexual harassment, these rules apply to all school education programs and activities. This includes all locations, events, or circumstances over which the school exercises substantial control over both the respondent and the context in which the sexual harassment occurred. So to discuss some important definitions under Title IX, Title IX defines discrimination as conduct that deprives a student of the benefit of an educational opportunity on the basis of sex and gender. Title IX defines gender-based harassment as harassment on the basis of a student's gender that is sufficiently severe, persistent, or pervasive that it creates a hostile educational environment or interferes with or limits the student's ability to participate in or benefit from the services, activities, or opportunities offered by a school. Note that this is different from the definition of sexual harassment, which we will discuss in the next few slides. So what is severe, persistent, or pervasive? So under Title IX, severe refers to extreme acts or actions that may include physical assault or severe threat of bodily harm. With regard to persistent, it is behavior that occurs repeatedly. Regarding pervasive, it is unwelcome behavior that is found throughout the culture or school environment. So it's behavior that is widespread, persistent, or consistent over time. So even though a conduct may not be severe in its own, it could still have a cumulative effect of creating a hostile environment.
So Nikki just went through some basic definitions and things to note as it pertains to the general definition of harassment. But as she noted, there is a different federal definition of sexual harassment under Title IX. So under Title IX, sexual harassment is defined in one of three ways. The first is that it could be a situation where a school employee is conditioning education benefits on participation in unwelcome sexual conduct. This is also known as your quid pro quo situation. Under Title IX federal regulations, sexual harassment could also be unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. Or sexual harassment under Title IX could also be sexual assault, dating violence, domestic violence, or stalking as defined under federal law. To be an actionable offense of sexual harassment under the federal definition, the school must exercise substantial control over both the respondent, the person alleged to have engaged in the conduct, and the context in which the sexual harassment occurred. To go over some examples of sexual harassment, just to give you an idea of what this could look like, it could be sexually suggestive remarks, verbal harassment or abuse. It could be sexually suggestive pictures or sexually suggestive gesturing. An example of sexual harassment could also be harassing or sexually suggestive or offensive messages, whether these messages are written on a piece of paper or maybe a student's clothing or maybe written in a bathroom stall. It could also be subtle or direct propositions for sexual favors, or it could also include touching of a sexual nature. Now we're going to go back to talking about harassment generally and just have a few things here for you to keep in mind. You want to remember that harassment does not have to include an intent to harm. You want to think here that the focus is on the impact of the actions, not the intent. Remember that harassment does not have to include an imbalance of power. It doesn't have to be students who may have different social capital or students of different ages or in different grades. It could be students that are on the same peer level. Remember that harassment does not have to be directed at a specific target. It does not have to involve repeated incidents, and it does not have to involve physical touching. Now let's take some time to talk about the obligation to investigate under the federal regulations of Title IX. A school is responsible for addressing harassment incidents about which it knows or reasonably should have known. So let's break that down a little bit more. For an example where someone knows about an incident, let's say a principal is walking through a school during the day and a student approaches that principal and tells them about a harassment incident that they are directly involved in. That's a situation where the principal, someone who has the authority to investigate and institute corrective measures, has direct knowledge of the harassing conduct and the allegations. Now, when we talk about what reasonably should have known means, let's say a principal is walking through the hall and throughout the course of the day, they're hearing a variety of students talk about a particular rumor being spread throughout the school involving two students. While the principal may not have seen the rumor that was posted on a social media account or who started the rumor, that principal does have, and it will be considered to have reasonably known about that harassing conduct because they've heard about it throughout the school climate throughout the day. And again, the principal is someone who is in the position to investigate or institute corrective measures. So that's an example of a situation where you can say the principal reasonably should have known about the conduct. I want to note there is a different standard for sexual harassment. Under federal regulations, a school is required to respond when it has actual knowledge of sexual harassment. Actual knowledge is defined as notice of sexual harassment or allegations of sexual harassment to a recipient's Title IX coordinator or any official of the recipient who has the authority to institute corrective measures on behalf of the recipient or to any employee of an elementary or secondary school. Again, this different standard is for sexual harassment, and the standard is the requirement of actual knowledge, and it applies to any employee of an elementary or secondary school. So remember that as it pertains to sexual harassment, all of you are mandatory reporters. So if you hear something, if you see something, you always want to make sure that you act accordingly when it pertains to allegations of sexual harassment. Some additional things to note here is that while there are some situations where the conduct may not rise to the level or meet the definition of Title IX sexual harassment, school administrators are still required to investigate alleged conduct under applicable state or federal anti-harassment and bullying laws or school disciplinary policies. Some examples of these other state or federal laws are the Tennessee Harassment, Intimidation, Bullying and Cyberbullying Law, Tennessee's Anti-Hazing Law, Title VI of the Civil Rights Act of 1964, or Section 504 of the Rehabilitation Act. As it pertains to retaliation, it's defined as adverse action against an individual for filing a complaint or participating in an investigation. Retaliation against any person who makes a report or complaint or assists, participates, or refuses to participate in any investigation of an act alleged is prohibited. And remember that retaliation may result in disciplinary action.
So you just heard an overview of what is covered under Title IX. We are now going to discuss the Title IX sexual harassment grievance process. This process is specific to Title IX sexual harassment complaints. Title IX and sexual harassment, the general requirements for responding to these types of concerns include LEAs being required to implement policies and procedures that address complaints and reports of sexual harassment. These policies should cover employees' behaviors, students, and student behaviors, while on school property, at school-sponsored activities, on school-provided equipment or transportation, or at any official school bus stop in accordance with federal law. Policy should be disseminated annually to all school staff, students, parents, and guardians. And the director of schools shall appoint a Title IX coordinator, and their contact information should be available for the school's community, and it should also be included in the LEA's policy. All employees should receive training on complying with their Title IX policies and how to comply with federal law. There are a few additional expectations for all Title IX personnel. And when I mention Title IX personnel, I'm speaking about the individuals in your district who are tasked with investigating Title IX and sexual harassment investigations. These individuals are required to serve impartially. This means serving without bias, not favoring an individual party, no appearance of bias towards complaints or respondents in general, or demonstrating support for victims or accused, avoiding sex stereotyping, and avoiding discrimination. This means having consideration for marginalized groups, such as people with disabilities, people of color, or people who identify as members of the LGBTQ community. Conflicts of interest should also be avoided by Title IX personnel, and this includes financial or reputational conflicts of interest to protect a school, commingling roles, and commingling those supervisory roles, or demonstrating any kind of past advocacy for victims or accused rights. Title IX personnel are also to avoid prejudgments of the facts as well. With the Title IX regulations, there are some general requirements for grievance processes. School districts are to ensure that their policies and procedures treat complaints and respondents equitably, that they include remedies designed to maintain the complainant's equal access to education, that they include a presumption that the respondent, that's the individual who's accused of the conduct, is not viewed as responsible until the investigation concludes and a determination has been made, that they include reasonably prompt timeframes for conducting an investigation, that they describe the range of remedies and sanctions that may come out of an investigation, that they describe the appeals process and range of supportive measures that could be made available to complainants and respondents, that they state the evidentiary standard to be used. There are two possible standards that could be used in a Title IX investigation. The first being the preponderance of evidence standard, and the second being the clear and convincing standard. District policies and procedures should also require objective evaluation of all relevant evidence. They should also exclude privileged information from being collected during an investigation. And they should also require that Title IX personnel be trained. Training materials must be posted on a school district's website, and that those Title IX personnel, again, should serve with no conflicts of interest or bias. With Title IX sexual harassment grievance processes, there are specific requirements related to reporting, and Natalie mentioned some of this earlier. Schools must prominently display contact information for the Title IX coordinator on their websites. Any person may report sexual harassment, and all staff must report acts of sexual harassment. Reports may be made in person, by mail, by telephone, or by email using the contact information listed for the Title IX coordinator, or by any other means that results in the Title IX coordinator receiving the person's verbal or written report. Such a report may be made at any time, including during non-business hours. With report intake under a district's Title IX sexual harassment process, if a school district employee becomes aware of any potential Title IX sexual harassment concerns, that employee should immediately contact the district's Title IX coordinator named in the district's policy. Some district policies may also require that employees contact the district's board attorney or other school personnel assigned to respond to Title IX issues. So please refer to your local Title IX sexual harassment grievance policies for specific details. Remember, if a report involves allegations of child abuse or criminal conduct, the school may also be required to report those allegations to proper authorities, which could be local law enforcement or the Tennessee Department of Child Services. When responding to a report of sexual harassment under a district's Title IX sexual harassment grievance process, the district's Title IX coordinator must review the report to determine whether the conduct potentially warrants a Title IX sexual harassment investigation. And remember, you're looking for 3 different types of conduct. Could it be quid pro quo, which would involve a school district's employee? Would it be unwelcome conduct that a reasonable person would determine is so severe pervasive, or objectively offensive, that it effectively denies a student access to the school's programs or activities? Or would it be conduct that is considered sexual assault, dating violence, domestic violence, or stalking under federal law? If a Title IX sexual harassment investigation is necessary, the Title IX coordinator must contact the complainant and offer supportive measures and explain the process for filing a formal complaint. If the complainant decides to file a formal complaint, or if the school district's Title IX coordinator signs a report making it a formal complaint, then an investigation will begin. So when initiating the grievance process, it's important to remember that supportive measures should be offered to your parties. Supportive measures help restore access to a school's educational programs, and they must be offered to both a complainant and the respondent. Those supportive measures should be offered to the complainant in an initial conversation that the Title IX coordinator is having with the complainant about the report. And if there's a need to offer supportive measures to the respondent as well, they should definitely be offered. Remember that students cannot be disciplined or removed until the grievance process is complete unless there's a need for an emergency removal. So supportive measures should not be viewed as discipline for a student. But if there's a need for a removal, then it can be done through an emergency removal if there is a threat to safety. Employees can also be placed on administrative leave or suspension without pay pending an investigation if there's a need for a removal of an employee. Supportive measures must remain confidential, and a school district must consider a party's wishes with respect to supportive measures. With the grievance process, there is also going to be a separate step for complaint intake. Remember, complaint intake starts when the formal complaint is submitted to the Title IX coordinator. And if the Title IX coordinator receives a formal complaint from a complainant, or if the Title IX coordinator signs a report making it a formal complaint, the coordinator must promptly provide all parties with written notice of the allegations and the grievance process, inform the parties of the prohibition against making false statements, inform the parties that they may have an advisor throughout the Title IX investigation process, and offer all parties supportive measures in an equitable manner. A complaint can be dismissed if it's submitted and it's determined that it does not meet the criteria to be considered sexual harassment under your district's Title IX sexual harassment policy. And it should be dismissed after the initial assessment and sent back to the school's administrators for review under different disciplinary policies. With regards to filing a complaint, remember that a complaint may file a formal complaint with the Title IX coordinator. And the Title IX regulations define a formal complaint as a document or electronic submission that contains the complainant's physical or digital signature or otherwise indicates the complainant is the person filing the formal complaint. The Title IX coordinator may also sign a report of sexual harassment, making it a formal complaint. When considering those complaints, again, complaints may be dismissed. There are some instances in which there are times where a complaint must be dismissed, and a complaint must be dismissed if the alleged conduct, even if proven, would not fall within the scope of Title IX. So if it would not be considered Title IX sexual harassment, it must be dismissed. Again, you want to send that information back to your administrator so that they can review it under other policies. And then there are times where districts have the option to dismiss complaints. If a complaint withdraws a formal complaint, a district may decide that they want to dismiss a complaint. If the respondent, the individual who is accused of the conduct, is no longer enrolled within the district or employed within the district, then the complaint may be dismissed. And then there are also specific circumstances that may prohibit gathering sufficient evidence. And in those cases, a complaint may be dismissed as well. The Title IX coordinator must provide notice of dismissal to the parties. And then complaints can also be consolidated if there are complaints that are received where allegations arise from the same facts or circumstances. So if you have complaints that are submitted from different parties, but they arise out of the same facts or circumstances, those complaints can be consolidated into one complaint and one investigation. For the grievance process, speaking more about investigations, an investigation should only occur if a formal complaint is signed by the complainant or the Title IX coordinator. So you cannot initiate an investigation without a formal complaint. The LEA is responsible for gathering all evidence sufficient to reach a determination regarding responsibility during an investigation. And the Title IX investigator must be assigned to initiate the investigation upon receipt of a formal complaint. Your Title IX investigator may be a person who is different than your Title IX coordinator, or it could be your Title IX coordinator. Investigations shall be completed within a timely manner, and all parties must receive copies of all evidence to review and be given 10 days to respond to that evidence. And parties must also receive a copy of the investigative report prepared by the investigator and be given 10 days to review and respond. At the conclusion of an investigation, the investigative report summarizing all relevant evidence and responses from the parties must be sent to a separate decision maker. All parties must have equal opportunities to present witnesses and evidence during an investigation. And schools must send written notice of any investigative interviews to witnesses and the parties when they are wanting to schedule interviews with those individuals. All parties must also have the opportunity to select an advisor of their choice to participate in the investigative process. That advisor can attend meetings with the parties and can review documents shared with the parties. And that advisor may be an attorney, but it's not required that they be an attorney. During the investigation process, there also may not be any prohibitions against the parties discussing the allegations or gathering or presenting evidence. And all parties must be allowed to submit written questions for other parties and witnesses after the distribution of the investigative report, but before the final determination regarding responsibility is issued. Parties must be provided with the answers to those questions as well and be allowed limited opportunities for follow-up. After the investigative process concludes, you then move into the determination of responsibility phase. At this point, a separate decision maker who is not the same person as your Title IX coordinator or Title IX investigator must take on the task of preparing a determination of responsibility report. The decision maker must review the evidence and investigative report using the appropriate standard for review. That's either going to be your preponderance of evidence standard or the clear and convincing standard. And the decision maker will issue a written determination regarding responsibility. Any substantiated charges can result in disciplinary action, including up to expulsion or termination. And remember that there is also an option under the Title IX regulations that allow LEAs to choose to incorporate live hearings into their Title IX investigation process. Please review your local Title IX policies for more details on the live hearing process. The last step of the grievance process is going to be the appeals process. Under the Title IX sexual harassment regulations and under your Title IX sexual harassment policies, parties have an opportunity to appeal. An appeals officer would be appointed in that case, and it would have to be a person who is not your Title IX coordinator, investigator, or decision maker, but a separate person serving in that role. Either party may submit a request for an appeal to the Title IX coordinator, and appeals must be based on one of the following: procedural irregularities, new evidence, or conflict of interest, and local policies may also outline additional basis for appeals. Appeals officers will prepare written decisions within 10 days of an appeal and share that information with the parties.
So you've just heard from Chandrea over the complaint intake, reporting, and grievance process. And as we wrap up this recorded training, we just want to review some additional things that you're going to want to take note of as you go through your Title IX processes. So as it pertains to discipline, remember, you're always going to want to review your discipline policy. And remember, as Chandrea stated earlier, you want to make sure you're reviewing your policy and consulting with your coordinator and your local board attorney if you have any questions. And remember that the discipline should not be issued until the conclusion of the investigation. You'll also want to make sure that you are ensuring consistent disciplinary action across the board. By this, we mean making sure that a particular student or group of students do not receive disproportionate disciplinary action. And remember that oftentimes discipline may be necessary in a situation, but it is often insufficient to completely remedy a situation. And speaking of remedies, you want to make sure that you take prompt and effective steps reasonably calculated to prevent the harassment from reoccurring. So here we've got some examples of things that could be remedies in a Title IX situation. So potential remedies could include creating a safety plan for the complainant or maybe a behavior plan for the respondent. You could also think about including support services such as counseling or tutoring. Examples of remedies also include disseminating notices or providing additional training for staff and or students as appropriate. As you're considering your remedies, you might also want to think about maybe making some stronger policies for your LEA or making your procedures a more detailed process. Additional remedies could include getting creative with reporting measures or measuring your school climate. It could also include creating anti-bullying and harassment initiatives or incorporating additional restorative practices throughout your school. Another note here that's important to remember is confidentiality. Remember, the confidentiality of the complainant, the respondent, and any witnesses participating or those who choose not to participate in the investigation should be respected as much as possible. Now, sometimes some information may need to be disclosed to the appropriate individuals as you're going through this process. But again, the goal here is to always keep the confidentiality of the persons involved respected as much as you can. So we have a few final notes as it pertains to record keeping. Now, while the specific things I'm about to go over are particular to Title IX sexual harassment investigations, they're also generally just good things to remember for all Title IX investigations. So as it pertains to investigation records, and these records include the investigative reports, evidence, determination of responsibility, recordings, transcripts, sanctions or discipline or remedies, these records should be maintained for 7 years. You'll also want to make sure that you're keeping a record of any appeal, as well as a record of any informal resolution. This also includes documentation of a school's response to all reports and formal complaints. And as was mentioned earlier, regarding training materials, they'll need to be posted on your LEA's website, as well as made available upon request. This concludes our overview of Title IX. If you have any questions, feel free to contact any one of us, myself, Chandrea, or Nikki. Again, we all work in the Tennessee Department of Education Office for Civil Rights, and we're here to help.